everyone. Thank you so much for attending today. My name is Paulette Lundy, otherwise known as the Maryland Legacy Attorney. I'm excited to talk about this. I'm always excited to talk about leaving a legacy, estate planning, getting your affairs in order, because I have witnessed both in my family as well as in my community the scores of individuals who have passed away and have left their families unprotected. And so it is imperative that we think about this now and just jump into action to make sure that we've considered everything and done everything that we need to do to put our affairs in complete and proper order. So let's get started. Today, we're going to be talking about families leaving legacies, how to protect your family, how to protect your assets, and how to protect your legacy. Overall, we want to leave something behind to our family, and it's not only money. People tend to think that when we talk legacy, we're talking only about money, and that is the farthest from the truth. We're talking about traditions. We're talking about family heirlooms. We're talking about customs, cultural customs, as well as values. Yes, we are talking about assets as well, and sometimes they're the biggest thing in your legacy, but there's so much more that makes up our family, makes up our person, and so we definitely want to consider the entire legacy and not just the financial legacy. So the reality that we have been dealing with over the past couple of years and even decades is that there are such few individuals who create an estate plan, and particularly 58% of Americans do not have an estate plan, and that's an alarming number. This is hazardous to your health and your wealth. And so we looked at a recent survey from Forbes that showed us the decline of those who are having estate plan. In 2017, it was over 40%. And if you just jump over to 2020, it is slightly over 30%. So it's rapidly declining instead of increasing. And so as a starter question today, I ask, do you have an estate plan? Or will you be one of those families that did not have an estate plan, who then was thrusted into a whole slew of things that they never anticipated, nor can they afford? So instead of being one of those families, if you are, let's talk about how we can repair that, how we can reverse that, and how we can avoid any negative consequences from not having it. But before we talk about the importance of having it, we need to talk about what is estate planning, what is an estate, and what is the process of planning your estate. The process of planning your estate is ensuring that you have the appropriate legal documents in place to help you manage your affairs and assets while alive, and to help authorize others to assist you if you become disabled. So it helps your family to help you during an incapacity or disability, as well as upon your death. So we no longer should look at estate planning in the old light, which is it's something that only is helpful when we die. Estate planning is relevant and applicable during your life as well as your death. There are several reasons why we find that people plan their estates, and they're very good reasons. One is to avoid probate, and we'll talk about what probate is later. The other is to avoid guardianship in a case of disability, whether it is for yourself as an adult or for a child or for your parents. But where there is a disability and an individual no longer has the capacity to care for themselves and no longer has the capacity to tell you that this is the type of help that I need, and they cannot give you authority to help them because of their disability, then we would have to engage in a court process called guardianship, and it's timely as well as costly. Another reason to plan your estate is to plan for a child with disabilities or special needs, and that is something, that's called the Special Needs Trust, or some other very relevant vehicles that we can talk about at another time. But it is very important and a valuable tool if you have a child with special needs to plan your estate. The other is to provide for and to protect a spouse, a child, or a grandchild. I know with my mom and my children, she was always giving them something, whether it was money or gift of some kind, or just sitting down talking to them about things that were near and dear to her heart. Planning your estate gives you the ability to continue giving to those children or to people in the manner in which you normally do or would like to, even in the wake of your departure. And finally, but not the only thing, is to disinherit a family member. But it's not always for bad reasons, because that family member doesn't behave or that family member would squander the money. Sometimes it's because that family member is well off or doesn't want to receive anything, that they decline to receive an inheritance. And so you disinherit them. We have many things that we should consider when we're talking about estate planning, assets and things of import that we should consider. Sometimes we don't remember that this is important. So, of course, if you have children in a family, you want to consider estate planning. If you have businesses and real estate, if you have property in and out of the state, you want to do estate planning. You may be a tech whiz and you may have created something. You may be an author, a writer, or a computer technical person, or an engineer of some kind, and you have intellectual and digital property that is of value. So you should consider estate planning. If you have life insurance policies, we tend to say that we don't have an estate, but a life insurance policy can be the vehicle or the item that funds your entire estate. If you have investments, you want to make sure that you do proper estate planning or coordinate your investments with your estate plan so that you understand taxable consequences as well as, required distributions or anything of the sort. We have jewelry, vehicles, and clothes. Clothes, we underestimate the value of clothes. However, let me go back. However, I think we had a famous talk show host, Alex Trebek, who had well over several hundreds of suits. And he donated that to men, men who were recently out of jail and who needed a second chance to get started. He gave it to them so that they can go to, that's wonderful, whether it's that you donate it to an agency or you give it to a person that you know would enjoy it, value it, and use it. It's still something to consider. We have scores of photos and other memorabilia that we would want to pass on, intangibles like family values and legacies, as well as maybe even passing on to a charity. But then if we have all of those things to consider, and we understand that estate planning helps us both in life as well as death, then what are some of the reasons why we don't plan? What prohibits us or prevents us from planning? And one of the biggest reasons is the I have time. I have time robs people of legacies, of generational wealth. It causes family discord. I have time. So we have a client that came to us some time ago, and she had been stricken with a very aggressive form of breast cancer, and we'll call her Marie for the sake of anonymity. Marie was 52 with 3 children. They were aged 23, 18, and 16. And Marie was told that she had an aggressive form of breast cancer and had very little time. Unfortunately, by the time Marie came to us and Marie began to inquire about estate planning, she did not take action in time. I would say more that she could not take action in time. Why? Because she became ill and no longer was capable of giving the authorizations that she needed. Unfortunately, her children, 2 of whom are currently adults and 1 minor, are going through a very lengthy, confusing, and complex probate process, as well as a potential guardianship process for the minor child. So you have 2 young adults who are now faced with caring for a minor child. And so what is probate? Probate is a public court process that is required when an individual has assets and owns assets only in their name. So it's a court process. It's a lengthy, it's timely, time-consuming, it's complicated at times. It can cause family conflict. And so now you have these 3 individuals who are marching through probate, trying to get everything in order because their mother did not have time to do so. Their mother actually thought she had time. She knew about this early on. She admitted that she just was too busy. She was a software engineer. And she was very busy trying to, make a decent living for herself and her children as a single mom. And she didn't have time to focus on this. And so I have time turned into there is no time. And you never want to be faced with that. But what are some other considerations that we could consider? And before we talk about that, we'll see the scores of people who also said that they had time, who did not plan their estates, young. Tupac Shakur, a rapper, Chadwick Boseman, we know him from the Marvel videos and the whole Wakanda movie, as well as so many other movies. He's credited with so many other movies besides the Black Panther, or Dr. Martin Luther King, as well as Prince. 57 is not old. And so these are people who had rather large estates that you would think that they would have planned their estates so that their families were not in probate court. Then we also have older and younger, Aretha Franklin, as well as Amy Winehouse. These are people who have a multiplicity of reasons to plan their estates, but they did not. And so their family are in probate court. Then you have another reason why people don't want to plan their estates is they don't want to think about it. We'll call this family the Harry family. Included a mother and a father who separated, and a sole daughter who, as she saw the decline in her parents, she, bouncing from house to house, trying to get the parents to understand that they're getting older and they're faced with medical conditions that could warrant additional help. In trying to get her parents to plan their estate and to give her the ability to help them in a more substantial way, they both declined, became very obstinate. And now both of them are riddled with dementia or conditions that do not allow them to sign over any authority for them to have their daughter handle their affairs. So what could have been handled in a few steps is now in court with a guardianship process for both parents, which was very costly and very stressful. And so when, as the sandwich generation, if you have your parents as well as your children, and you're now faced with dealing with their conditions as well as helping your kids grow up, it's a lot. And so it's incumbent upon us to ensure that we are talking to our parents and really helping to lead them to make the right decisions, which include planning their estates and giving them the opportunity to make the decisions. We're not robbing them of the opportunity to make decisions. They can put in place whatever plan they want, so long as it's effective and comfortable for them. So not wanting to think about it, not wanting to talk about it is a bad thing that will cause us to deal with much greater expenses. In line with that, we have individuals who say doing my estate plan is too expensive. It's way too expensive. So I tell people, if you look at this visual, I tell people you can do it now and it could be a little costly, or you can, do it later where it will be very costly. So now really is the section there with less, it looks like change, but it's less expensive. You can control the cost by choosing an attorney that gives you a flat rate and you know exactly what to expect and work with that attorney. Or you can just continue to load up money and pile up money, or take money away from your family because you have passed away now and they're in probate court. There are other reasons why people don't plan. Some say they don't care. Others say they don't understand estate planning. Some say it's overwhelming and they don't know where to start, or they actually get stuck on certain decisions and are indecisive about who should actually serve in what roles. And then other people say, I don't want to talk about it because if I do, I may die. But the reality is we are all going to die. It's just a matter of when and how and what did we do in preparation for it. And when we don't prepare, not only do we leave our family members like this, crying and in pain over the loss of a loved one, but it also leaves them in turmoil like this, where they don't know where to start. They don't know how to pick up the pieces. They don't know whether or not the children can still go to college and whether or not they can afford to live in the home. They just don't know. It causes a myriad of concerns and confusion that we would want to avoid. The one thing that we have to consider is the fact that there are several ways in which property actually can pass to our loved ones. It can pass through ownership or operation of law, meaning that you and, let's say, your husband own a home and you're joint owners with right of survivorship. And so when one of you passes away, then the other one automatically gets it. Now, there are some people who do that with their children as well. as a means of avoiding what they consider avoiding probate. And we kind of refer to that as the poor man's estate planning. And so there's some things that we don't recommend. One is having your children's name on your deed or on your bank account, but we can talk about that individually at a point when we're talking specifically about your situations. But we would recommend that you do not do that because it can have more taxable consequences than anticipated. Then another way to pass property is through beneficiary designations. For instance, like your insurance plan or a retirement plan, a pension or what have you, you would have an individual who would be the designated beneficiary. In the event that something happens to you, they're paid directly. Now, what we need to understand about that is that there are many people who may plan their estate, or they think that they've planned their estate in its entirety, but forgot to touch the beneficiary designations. And so they don't jive. So you have, you're saying that you leave everything to XYZ, but then when we look at your beneficiary designations, it's to A, B, and C. And that is going to actually take precedence over your estate plan. So you have to make sure that your estate plan is coordinated with those policies and those plans that have direct beneficiary designations. One of the things that we actually advise most of our clients, and of course it's on a case-by-case basis, is if you have an insurance policy, then have it flow through your estate plan, whether it's a trust or not, so that money is retained in one place and the individual who has been designated as either your PR or your successor trustee would be able to galvanize your assets and then distribute them accordingly from one point, as opposed to having to kind of figure out all of the different accounts that exist and how they need to distribute them. And especially if they don't jive with your estate plan, it causes great confusion, a waste of time, but it can cause a lot of delay in getting inheritances as well as other assets and finances to family members who may very well need them for their very next phase of their survivorship. The other way of passing property is through a last will and testament. And that's the thing that I feel like many communities have known for so many years, is that I need a will, I need a will, I need a will. Well, I tell people, if you have nothing else, then definitely at least have a will. But if all you have is a will, means that your family will have to go through probate. Again, we talked about probate earlier and the fact that probate is a public court process. And if you know anything about court processes, you know that you are not in control. There are strangers all in your business, and they make decisions about your business. And some of those decisions do not help your business. And so I tell people, avoid probate at all costs, because if you look at it from the perspective of a pizza pie and you think about the slices, when you go through probate court, there are so many people who get a piece of that pie before your loved ones and your heirs do, because there are costs that are so ridiculous that have to be paid. For instance, if we say that let's say we have $1 million estate, and that is really not hard to do, especially if you own a home, you may have a life insurance policy, you may have some money in the bank, you have some vehicles with value, as well as maybe some personal property. If you have to go through probate for that estate, you will be paying upwards of $40,000 in fees. And some of those fees go to attorneys. And so here I am, an attorney telling you don't do it. Why? Because it doesn't make me happy to gain money through that means while your family is suffering. And so to avoid that, there are other ways that other estate planning tools that you can choose to avoid that, being the next one, a living trust. A living trust, whether revocable or irrevocable, will help you avoid the public court probate process. It's a document that I really call a will on steroids, meaning that it has all of the tenets of a will with the exception of the public probate process. A living trust is confidential, it's private, it's not a public document that has to be filed with any public agency. It is between you, your successor trustees, as well as your beneficiaries. Your successor trustees are individuals who will handle your estate upon your death. during your life, you are considered the trustee because it is a legal document that you still have full control over, as well as full control over the assets in your trust. You can take them out, put more things in, you can make gifts, you can do so much. It gives you great flexibility, but it gives you protection, and it also can give your beneficiaries protection. I mean, we all have a family member who you kind of think twice before you give them the money. And because, they say the money is for A, but then you find out later that they used it for C. Well, if you have a family member like that, whether it's your child or some other family member, but you do desire to do something for him or her, then you can put parameters around how that gift can be distributed, when it can be distributed, how much can be distributed, what the beneficiary will have to do in order to get a distribution. I have had families who have been dealing with a family drug issue, and so that beneficiary had to actually take drug tests. There are other families that say upon marriage, then a distribution here. When their child actually has a child, then they can get this level of distribution. So you can put parameters around your gifts to people. After all, it's yours. You earned it. You worked hard for it. So you get to decide how it should be used and to whom it should be given. The other way that property passes is through intestacy, and that's the whole probate process that we talked about that we want to avoid at all costs. And probate, I said, is time consuming. It can take up to 12 to 18 months in probate court, and that's like a short probate process. We all know someone whose family members have been subjected to probate, and they tell you that it's a nightmare. And knowing this, why then do we still allow it to happen? So if we know that going through probate, having to deal with probate is time consuming, is lengthy, is complicated, it's costly, it invites claims against the estate because you serve notice in the newspaper, basically alerting people that, there's some potential assets and money out there, and they come running. Sometimes it's a creditor, sometimes it's a family member who is challenging the will. And, it could be a family member who hasn't helped nor has been seen for ages, yet they said they had a conversation with your deceased loved one, and that person said that they can have the house. Nothing is in writing, and then all of a sudden we're thrusted into litigation, which then will increase the costs associated with the probate process, because now the attorney is going to charge you an hourly rate to litigate, and he or she is going to make more money than your family members who you forgot to put things in order for them. So it's a process that's really not designed to ensure that we pass on generational wealth. And it is a process that's designed to put money in everybody else's pocket. And so I call that a lawsuit that you file against yourself with your own money for the benefit of everybody else, for the benefit of your creditors. And I'm sorry, I don't see where there's sense in that. You see that there's executors' fees, there's attorneys' fees, you might have to have things appraised, you have to deal with creditors, you have filing fees, and not to mention, this is a big one, and people don't understand it, nor do they think about it. When you have a will or you die intestate without a will, a personal representative has to be appointed to manage your affairs. That personal representative may have to file a bond and get a bond. And a bond cannot be obtained if that individual either has a criminal history or bad finances and, their credit is not good. So the very loved one who will take care of your affairs and will see to it, and you're like, oh, such and such will handle it, I don't need to do a will. Well, that person may be excluded because of their financial situations as well as their criminal history. So why leave anything up to chance? You've worked all of your life. You've amassed some wealth, whether it's a house or whatever it is. Why don't you continue in this trajectory and make sure that even in your absence, things are handled as well as they would have normally have been had you been around. So here are just a couple of other facts that I think are important to know, because, when we talk about planning our estate, another important reason is because women are outliving men. And so if you have a married couple, the likelihood of the male dying first and leaving the woman behind to deal with the children, the home, the assets, the debts, or whatever the case may be, is great. 36% of women 65 and older are widowed, compared to 12% of men 65 and older. And so if you are in a marriage and neither you or your husband has begun the discussion about estate planning, as a woman, I will tell you to sound the alarm right away. No, you are not leaving me here to deal with this mess. Let's deal with it now, so that if it's you, then I will be okay. If it's me, then you will be okay. These are conversations that we have to have. And I even will go as far as telling you that these are conversations that we have to have when we're dating, to understand what is this person's mindset regarding planning your estate. So women also are the fastest growing group of entrepreneurs in the United States. So we are amassing more assets, we're accumulating more wealth, and so we have to protect ourselves. There are a number of organizations now that I follow and I'm a part of that talk about women investing. And so we're investors, we're business owners, we're entrepreneurs, we're creative, we're inventors. And so we have to ensure that we're protecting our investment. In 2019, Caring.com survey results said that Black respondents were the most likely not to know how to get a will or a living trust. It's not something that was readily discussed in our families as we were growing up. And so now we need to talk about it. We need to close the gap of information as well as the gap of wealth, and to make sure that we're doing the right thing. Caring.com also reported that a number of Americans with a will or estate plan continues to decrease. And we saw that in the very beginning with our Forbes chart, right? Our Forbes graph. So what do we do, and how do we mitigate the risks, and how do we protect our assets? Since statistics are showing that men are likely to die first, you want to make sure that our family is protected. You want to make sure that you have all of the estate planning documents that will help you in the case of incapacity, especially making sure that those documents have specific instructions regarding who you're designating as the person who will handle your affairs, whether it's a personal representative or a trustee, a successor trustee. You want to make sure that you have proper insurance plan. My goodness, that to me is a real important aspect, because for those of us who don't have these humongous estates, which we think we should have in order to do estate planning, we can fund our estate plan simply through an insurance policy. And so that is something that we need to talk about as a family to ensure that we have the appropriate level of insurance. So let's say you're a two-family home, a two-income home, and God forbid something were to happen to the first individual, one of the individuals, and not even that he or she passes away, but that he or she becomes incapacitated and no longer is that income available to the family. So now you're thrusted into a situation which we saw a lot of in 2020 and 2021 with the pandemic, where there's only one income. How do you replace that income? So with the proper insurance plan, you can have a plan that has a cash value where it can serve as income replacement. Not only that, if you have the proper insurance plan, it may have coverage for critical illness or injury or something else that would happen or could happen that would incapacitate you and not allow you to work and earn to contribute to your family. So we really, as a community, have to talk about insurance and the role that insurance is playing in sustaining our family and also protecting our children. My husband and I have insurance plans for our children. We try not to talk about it at home too much so they don't know and start making have some sharp ideas. But we have plans, and they've been covered since they were teenagers. So when they turn, 50, 60 or whatever, or even sooner than that, we're going to turn it over to them and let them manage those plans. But they have access to, some income in their older years. But getting them started now, so when they become adults, one, they see the example and they follow. Sometimes we don't have good examples for others to follow, and so then we continue these cyclical things that don't push us forward as a family and as a community. The other thing that good estate planning does is it helps to minimize your tax exposure. And we'll talk about that in a minute. But there are 5 documents that I adamantly believe that we need to protect ourselves as well as our loved ones. That is a power of attorney, a healthcare directive, And if you have children, you want to make sure that you have guardian nominations. And either you want, if you don't have some of those things, you want to make sure that you have a last will and testament and a trust. Now, the power of attorney is really important because that just basically says, if I cannot handle whether it's my financial matters or my medical matters, I designate an agent either to speak on my behalf now or when I become incapacitated. So it can be effective today or it can spring into effect upon incapacitation. Whatever you choose, whether it's now or later, it just needs to happen. It just needs to exist so that your family members can jump in and assist you at the snap of a finger in the event that something happens. So you want a financial and a medical power of attorney. Then you want a healthcare directive. That is a very specific document that really speaks to end of life planning. When you're basically on your deathbed and your doctor basically says to you or your family that there is no chance of recovery because you either have a terminal illness, an end stage condition, or you're in a vegetative state. And basically you make the decisions while you're competent, capable, and healthy to say that if these three things occur, this is what I want done. I either just want palliative care, keep me comfortable, no pain, or I do want medication to try to extend my life or whatever the case may be. But there are some very specific things that we talk about in an advanced healthcare directive, and you get to decide. So your family is not confronted with the responsibility to decide, well, the doctors say that, she's not breathing on her own and really, she's brain dead. So do we or do we not pull the plug? I've heard scores of reasons and examples where doctors have said, I don't think that it's worth allowing this person to remain on the ventilator, and some people decline. A woman just last week testified at an outing that we had with our church. That was what was said about her son, and she said no, and lo and behold, he woke up. Now, is that the norm? I don't know, but what I do know is that you can decide for yourself how long you would like to be on a ventilator, how long you would like to be kept, medicated or intubated or whatever the case may be. So your family doesn't have to decide for you, and you can tell them when you want it to be over. Like, I don't want to sit like this. I don't want to lie like this. I don't want to be incapacitated like this forever. I would rather 30 days, 7 days, or whatever the case may be. So there's some clear decisions that you get to make, and your family members, the person who is your agent, gets to carry it out. HIPAA is the Health Insurance Portability Act, and basically it's a waiver that gives your health agent, the person you've identified to speak on your behalf, the right to get medical information from your doctors. Again, if you have children who are minors, if you do not nominate guardians, and it is now in the presence of a court process, then anyone can step forward, and then they will kind of like compete to get the authority to manage and care for your children. That just took my breath away, because if you're a parent like myself and my husband, we're very specific about what we want our children's experiences to be, how we would like them to grow up as young adults contributing to society. And so therefore, we set on this path to exert energy and effort as well as money in that direction. But of course, too, we want to make sure culturally as well as their values that, they're intact. And so we set out to do that too. And so you don't just want anybody to come in the picture and take over the care of your children. You want to identify individuals, whether it's a married couple or a single person, as a guardian for your children. This person has to be equipped to handle the financial situation with your children, to handle the personal affairs. If there is a medical situation, you have a child with disabilities. Those are important decisions to make so that you know that in the event that anything happened to you, that your kids will be well cared for, will be loved and protected, almost as close and as good as you. Don't leave it up to the fact that you have family members and you know that they'll come forward and take care of your children. I'm dealing with a number of cases like that right now, and I can tell you that it tears people apart. And they often say, well, why didn't such and such handle this? Because now the families are battling as to who has the kids and who's making decisions and who's paying the money. And so there's so many considerations that must be accounted for. And while you have the presence of mind to do it, I say do it now, so that you're not subjecting your kids to that, as well as to other people in their lives. A last will and testament, we kind of talked about that. If we can avoid going to probate, we want to do that. And the only way to do that is to have the next thing called a trust. If we were to do a trust, we will have what we call a pour over will. And that is sort of like a protective measure in the event that we do not fund, and we can talk about funding in a minute, we do not change the title of all of your accounts into the name of the trust. The pour over will is like a parachute that would get those items and tell the probate court, don't put it through the full probate process. Consider it to have been in the trust and let it be managed by the trust. And so those are 5 documents that we would want to consider for our loved ones. I kind of went through the pros and cons about them, but as I mentioned, a will is only really relevant when you die, whereas a trust has life and death implications. A will does not plan for incapacity. When you have a proper estate plan with a trust, you will have other documents that can assist you in planning for incapacity, such as the power of attorney, as well as the advanced healthcare directive. Your personal representative has to be appointed by the court. We talked about that with the bond, whereas a trust, your successor trustee does not need any court oversight or court involvement. A will is a public record, but a trust remains private. With a will, the court is always involved until the case is closed. For some cases, it's been years. It's very, state specific. So what's important about that is, let's say you have property in multiple states. If you have a will in Maryland, but you have a home in Florida, you're going to have to probate in Florida for that home in Florida, and you'll probate in Maryland for your assets in Maryland. Whereas if you have a trust, it is not state specific, and it can deal with all of the assets that you have wherever those assets are. And so that is a benefit and a bonus to not have to deal with multiple probates in multiple states. And this is why when I speak about having an estate plan, I talk about it in the vein of being comprehensive and effective. Because if it's not comprehensive, it means that it doesn't contemplate all of your assets and all of your issues. And every family is different. And so you have to make sure that you're having specific conversations with your attorney, the attorney that you choose, about your situation, holding back no information. This is not the time to be shy or coy about things or embarrassed. That's why we're here. We're here to clean up your affairs and to make sure that you and your family are positioned in the best possible light. And so knowing that there are assets, in other states or family members who can be problematic and concerns that need to be addressed, those are things that matter to your estate planning attorney. And so we need to know that. Lastly, we said that probate is time consuming, can cause delay. It can cause delay for your family members, and then they don't have access to either the money or the assets that they need to continue living. Whereas with the trust, there are no delays like that. And things can happen in a more quicker pace. I mentioned minimizing tax. Understand that there are some tax considerations. There's the inheritance tax, where non-exempt beneficiaries, if you give a gift, may pay an inheritance tax of about 10%. Who are non-exempt beneficiaries? People who are not your immediate family members. And so sometimes we want to leave a gift to a third or fourth cousin. That could be problematic. And while you think you're doing good, it could cause a taxable consequence for that individual. So those are things that we would want to talk about. Who do you want to leave an inheritance to, and what's their relationship, so that we can understand, what are the taxable consequences and who's going to pay that tax? Are you going to cover it for them? Or are they going to be responsible for it? The other bucket of taxable considerations is the income tax, state and federal. And that is the tax that you pay on any income that you receive, whether alive or not. So while you're alive, you're paying taxes every year, right? As through work, you're paying your taxes. And then when you file your tax return, if it was an under collection or overage, then you either will pay them if you paid not enough, or you will get a refund if you paid too much based on any deductions that you may have had. But in death, your estate, if it's still collecting income, let's say you have a home or several homes, or you have investments that yield income while you're dead, then that's where your PR or your personal representative or your trustee will be involved in making sure that you're paying your taxes either on your estate every year or you do your final year. So those are considerations that have to be discussed. And then estate tax, we have some room. So if your estate is over 11.58 million per person for federal and over 5 million statewide, then you will probably be subjected to a 40% tax rate. And so when we see that our clients have what we call a taxable estate, meaning it's over the 11.58 federal and over the 5 million state, we start looking at strategic ways to minimize tax. We don't want to talk about, it's kind of tax avoidance, but it's legal. There are opportunities for you to avoid paying a huge tax rates. But that comes through planning your estate and looking at the strategies that are available for you to take advantage of. We like to talk about certain politicians who didn't pay any taxes, but they made a whole bunch of money. We would have to look at the tax returns to see, well, what advantages did they take, and what was legitimate, what was not legitimate. And so we want to look at the legitimate ways to minimize taxes. And it's possible. It's really possible. And so if we don't talk about it, we don't know, and we may be paying more than we should. But let's talk about it so that we can ensure that we're doing the best for your family and for your estate. So wrapping up, you're probably asking me, I heard a lot. And why do you say that I need an estate plan again? I hear you. It's to avoid unintended beneficiaries. It's to provide for your family. It's to avoid guardianship and unnecessary probate-related costs that could be very high. And it's to ensure that you coordinate your beneficiary designations with your overall estate plan, and it's to minimize tax exposure. It is to straightforward, get your business in order, get your house in order, get your affairs in order. We've heard horror stories about people who said, I have time, I don't care, I'll wait, my family will take care of it, they know what I want, and boom, when it happens, no, they don't know what you want. No, they can't take care of it for many reasons. And so let's make sure that we are taking care of our family and ourselves and our assets and our legacy when we can. And so creating an estate plan is key to creating generational wealth. I'm sure we've been hearing a lot about the gap in generational wealth and the fact that we as a community may be behind in creating wealth for our successive generations and things that are robbing the wealth from our family members. My goodness, why would we allow that to happen if we have control and we can do things today that can change the course and the future of our generations? Your children, your grandchildren, your great-grandchildren, they are depending on you, your community, your family members, for those who don't have children, your aunts, your uncles, the organizations that you hold near and dear. All of those people are, waiting on you to do the right thing and to ensure that your money doesn't get or your assets don't get stuck in the coffers government where it's just sitting there waiting for it to be collected and then eventually going to things that you may never wanted it to pay for. And, I'm part of the sandwich generation. And so I have children and I have aging parents. And so I had to do a lot of estate planning, and I do a lot for other families who may be facing aging in place issues as well as nursing home issues. And there are so many strategies that can be employed to ensure that you protect your assets, you protect that family home, and it doesn't have to be taken because that family member had to get Medicaid, or you have a disabled child or a person and you would like to leave, and you're the caregiver and you would like to leave behind instructions on how to care for that individual, as well as here are the finances to care for that individual, but also not excluding them from being able to receive government benefits. There's just so much that needs to be talked about, considered, and dealt with. And so I urge you to not procrastinate any longer, to ensure that you're thinking about it and then taking action. It's not enough just to say, I need to get my estate plan done. You have to say it and then do it. So we challenge you today to call our office so that we can help you to get your estate plan in order. I'm Paulette Lundy, the Maryland Legacy Attorney. I don't particularly care to handle your family's affairs in probate court because it is wrought with emotion, and I end up up actually doing more counseling emotionally than I do counseling legally in that space. While I don't mind, I would prefer to do it while we are level-headed, clear, and here, and are able to help you navigate the complexities now. We do the heavy lifting. And so we're excited to help you. Our legacy is to help you to create yours. So please don't hesitate to call us. Procrastination, it cannot be a thing that you are known to be dealing with. It's no longer an option. It's a necessity. And I was talking to someone the other day who said that, when you're dealing with protecting your family through insurance, it's not about whether or not you can afford it. It's a necessity. And all the other things we have to talk about whether or not we can afford, because we need to get this done. So don't hesitate. Give us a call. We're here. We're here today. We're here tomorrow. We can be reached even by email after hours as well.